which was started in 2016. Together is known for the welfare of underprivileged throughout the country. As of now, Together has organized various programs like cloth donation drives, free legal aid services, the uh, the grand treat or the bhandara, which you normally say, Diwali celebration with blinds, Children's Day celebration in old age home, etc. Apart from social welfare programs, we also organize seminars, workshops, webinars, conferences, quizzes, etc. for students, which mainly concerns law students. The purpose of organizing these events is to make students aware of their surroundings and help them to develop new skills. Normally, we charge a nominal fee from the participants. The fee collected therein is used for donation purposes only. One thing which makes Together stand out from the rest is that Together is wholly student-run organization, and hence we do not charge any fee from being a part of organization. That is, we do not charge any which other organization call it social welfare fee or other fee named like named after it. We do not charge any fee for being a part of our organization. Everyone is free to join our organization, provided you are willing and dedicated to work for our organization. For more information, you may visit our website. Next, before beginning our session with Priti Ramani ma'am, I would like to give a brief about Priti Ramani ma'am. Priti Ramani Nayyar ma'am completed her graduation in LL.B in the year 2006 from Guru Gobind Singh Indraprasth University. She was an academically bright student. She was the university topper and gold medal achiever. Thereafter, she completed her LL.M from Delhi University in the year 2010. Needless to say, she was a topper and gold medalist there too. Apart from her studies, she was equally active in extracurricular activities of the law school, which entailed traveling to foreign countries and representing her law school in moot court competitions. Now coming to her professional experience, she has worked as law researcher with Honorable Judge Mukul Mudgal, former Judge High Court of Delhi and former Chief Justice of High Court of Punjab and Haryana. Apart from this, she has also worked with top-tier law firms like Luthra and Luthra. There she used to render corporate legal advice to prominent international entities and host of startups and chartered accountancy firms. She has also assisted several homebuyers file their claims before the insolvency resolution in the JP insolvency matter. Her subject of interest are commercial laws, international humanitarian law, intellectual property law, foreign direct investment laws, and alternate dispute resolution. She also is a part of various other law schools where she delivers guest lectures. Apart from this, she has been actively engaged in presenting papers in various national and international seminars and has published research papers in reputed journals. Currently, she is a member of Bar Association of High Court of Delhi and is a PhD scholar of Guru Gobind Singh Indraprasth University. I think the day will fall short if I continue to mention about her achievements. So I request ma'am to please take over and enlighten us with your words of wisdom. We are lucky to have you with us, ma'am. Over to you, ma'am.
Thank you so much, Ishant. Thank you so much for your kind words. The topic of my presentation today is 1 year suspension of insolvency proceedings under the Insolvency and Bankruptcy Code 2016, issues and challenges. Now, all of us have been reading in the newspapers about 1 year suspension of insolvency proceedings under the IBC 2016, and recently the announcement was made by the government in view of the disastrous impact of COVID on the Indian economy. What is insolvency resolution process? What are the implications of this move by the government? I'm going to explain it in my presentation today. Before moving forward, I believe it is important to know the difference between insolvency and bankruptcy under the code as well as generally. Now, insolvency is a state of financial distress, a state wherein a creditor is unable to pay its debts and its assets fall short and of paying the debts. It's a state. Bankruptcy, whereas it is a process and it's a court order whereby the insolvent entity is formally declared bankrupt. An insolvent person may file for bankruptcy, may not file for bankruptcy. Now, recently in 2016, the government enacted the Insolvency and Bankruptcy Code. The highlight of this code was a departure from the old law, wherein the company which was insolvent could only start liquidation proceedings at the primary stage. But in this case, in the insolvency proceedings under the Insolvency and Bankruptcy Code of 2016, a company which has gone insolvent, all efforts are made by the NCLT and the insolvency resolution professional appointed by the NCLT to revive the company in the first instance. And that process is known as the corporate insolvency resolution process. If that process fails, then the company is liquidated and so on and so forth. So basically, the Insolvency and Bankruptcy Code was enacted to provide a reorganization and insolvency resolution of corporate persons, partnership firms, individuals in a time-bound manner, and for maximization of the value of assets of the corporate person undergoing insolvency, so that it entails a win-win situation for all the parties involved in the corporate insolvency resolution process. Now, the move by the government has suspended the insolvency proceedings under the Insolvency and Bankruptcy Code 2016 for a period of 1 year. What is insolvency process? I'll give you a brief overview before actually venturing out to explain the repercussions of the move of the government. An insolvency process is a process which is initiated by a default by a corporate debtor. What is default under the IBC code? It is explained in section 2, clause 12. Default means non-payment of debt when whole or any part of installment of debt becomes due and payable and is not paid by the corporate debtor. What is debt? Again, the code provides a definition under section 2, clause 11, which says that debt is a liability or obligation in respect of a claim due from any person, and it includes a financial and operational debt. This brings us to the definition of a financial creditor and an operational creditor. Basically, the main creditors envisaged by the code are financial creditor, who could be any person to whom a financial debt is owed, or a person to whom such amount is legally assigned or transmitted. For example, banks and financial institutions may be termed as financial creditors. What is a financial debt? A financial debt has also been again defined in the code, which means a debt along with interest, if any, which is disbursed against consideration for time value of money. Now, a hallmark of financial creditors is that they get to be part of the committee of creditors. I'll explain it in due course. Committee of creditors, which is formed under the code by the NCLT. And what happens and what powers do they have? They have been given special powers. They can vote in favor of the insolvency resolution or against it. Now, in contrast to the financial creditors, we have a concept of operational creditors. Now, what does an operational creditor mean? An operational creditor means a person to whom an operational debt is owed. What is an operational debt? It basically means a claim in respect of provision of goods or services. as defined by Section 5, Clause 20 of the IBC. For example, I am a vendor and I distribute spare parts to some manufacturer who then assembles it and sells the same in the market. Now, a very common condition, a very common market condition, and a very common practice is to sell the goods on credit. It's in practice all over the world. Be it domestic transactions, be it international transactions, the business, the commercial transactions run on credit. So in this case, I supply those spare parts to the person manufacturing electronic goods, and there is a contract between us that that person who is manufacturing the goods would pay me after a period of 60 days. Or there may be a stipulation that if he sells 10% of his goods, my invoice then becomes due and payable. So what happens in the case that person does not pay me after the stipulated time? Under the code, I become an operational creditor, in simple terms. Now, there were cases in the Supreme Court, the most celebrated case being the recent judgment on 25th January 2019 of the Supreme Court in the case of Swiss Ribbon versus Union of India Private Limited. Sorry, Swiss Ribbon versus Union of India. And wherein the Supreme Court, there was a dispute and there was an allegation. The averment was that the court discriminates between the operational creditors and the financial creditors, since operational creditors fall in line behind the financial creditors, and financial creditors, since they have a right to vote in the committee of creditors, but this right has not been given to the operational creditors. There was a lot of hue and cry since the inception of the court for the reason that the code made a stark differentiation between the rights and obligations of financial creditors and the operational creditors. But in this case, the Supreme Court laid to rest all the controversy, stating that the distinction between the financial creditors and the operational creditors under the code was based on intelligible differentia, and hence it satisfied the test of Article 14 of the Constitution. The court also held that the rationale of creating a distinction between the operational creditors and the financial creditors seems to be a plausible one, since in most of the transactions, there is a huge amount of difference between the debt owed to a financial creditor, that is a bank or any financial institution, or a simple operational creditor who just supplies goods and services to the corporate debtor. Again, this distinction before the Supreme Court ruling also in Nikhil Mehta versus AMR Infrastructure Limited, the judgment of the NCLAT, and in Akshay Jhunjhunwala, there was a judgment of Calcutta High Court. It was held that operational creditors are neither able to decide matters regarding the insolvency of the entity, nor they are willing to take the risk of postponing the payments for better future prospects of the corporate debtor. So hence, the primacy given by the court to the financial creditor seems to be on a sound footing. It is indeed true that more importance has been given to the financial creditors under the Insolvency and Bankruptcy Court. But if you see the figures given by the Insolvency and Bankruptcy Board of India in their quarterly report of October to December 2019, you will see the share of the operational and the financial creditors almost same. So the code is, to give you a practical perspective, the code is already being used, almost 50-50 by the financial creditors as well as the operational creditors. Now, Coming to the corporate insolvency resolution process, Section 4 of the Insolvency and the Bankruptcy Code specifies the amount of debt, amount of default, in respect of which the corporate insolvency resolution process can be initiated by a corporate debtor. Now, initially, that is before 24th of March 2020, wherein the notification was provided by the government, whereby the government increased the minimum threshold limit to initiate corporate insolvency resolution process. Initially, it was rupees 1 lakh. So if any entity defaulted 1 lakh rupees, the operational creditors and the financial creditors had the right to initiate the insolvency resolution process under the code. But after the government's notification dated 24th March 2020, in view of the COVID pandemic, and to save a lot of small entities from going into liquidation, the government increased the minimum threshold limit from rupees 1 lakh to rupees 1 crore. So that's a significant increase if anybody has to initiate corporate insolvency resolution process against a corporate debtor. How is the corporate insolvency resolution process initiated? Under Section 7, the financial creditors are empowered to initiate the corporate insolvency resolution process. Now, one thing which I would like to apprise everybody is that initially the definition of financial creditor was quite narrow. But after the insolvency case against JP Infratech Limited, pursuant that, and considering the fact that a lot of home buyers were involved and the builders had taken money from the home buyers as well as the banks and financial institutions to fund their development projects, it was decided to include home buyers in the definition of financial creditor as well. So now, what is the scheme? The scheme is that financial creditors, the definition of financial creditors also includes home buyers. And as per the latest amendment, 10% of the home buyers or 100, whichever is less, if they are aggrieved by the builder, they can approach the NCLT for an insolvency resolution process. Again, coming to the operational creditor, operational creditors have been empowered under Section 9 of the code to initiate insolvency resolution process. And a third aspect that the debtor itself may initiate insolvency resolution process under Section 10 of the Act. Operational creditors are required to give an insolvency notice of 10 days before they initiate the corporate insolvency resolution process. That's under Section 8, along with some other basic documents which both the operational creditors and the financial creditors have to submit before the NCLT to initiate the corporate insolvency resolution process. Now, after the application is submitted to the NCLT has to decide the application within 14 days of its admission. This is provided under Section 15 of the code. Thereafter, within 14 days, the NCLT has to appoint an insolvency resolution professional. Now, what is an insolvency resolution professional and what are his or her duties under the code? An insolvency resolution professional, the guidelines have been given under the respective rules, basically chartered accountants or qualified lawyers. They are professionals who manage the entire corporate insolvency resolution process. They oversee, under the supervision of NCLT, of course, they oversee the entire corporate insolvency resolution process, and the control and the management of the corporate debtor is handed over to them under this process. Now, what happens when an insolvency resolution professional is appointed? As per section 15 of the IBC, he is required to make a public announcement. You must have seen in newspapers, a lot of insolvency professionals give advertisements that such and such a corporate entity has been, there has been an insolvency proceeding initiated against such and such corporate entity, and you are required to file your respective claims with respect to that corporate entity, whether you provided any funds to that corporate entity or not, and what are the details, and the details of the claim, the checks, the amount of checks, when and where you paid, etc., etc., the details of the people who would file the claim, etc. So that's done under section 15 of the code. After this, after the submission of claims, under section 14, a moratorium is declared. So what's a moratorium basically? A moratorium is that any continuation or initiation of any legal proceedings against the corporate debtor is stalled, right? Until and unless the corporate insolvency resolution process is in vogue, there is a moratorium. The assets of the corporate debtor cannot be transferred. There can be no enforcement of security interest against the corporate debtor. There can be no initiation of legal proceedings against the corporate debtor. All existing legal proceedings are suspended, and there can be no recovery of any property from the corporate debtor. Going forward, after the insolvency resolution process is completed, during the course of the insolvency resolution process, it is the obligation of the IRP, the insolvency resolution process, to conduct due diligence, to verify assets of the corporate debtor, to involve all stakeholders, and to procure a resolution plan. After assessing claims made by all the creditors. And for this purpose, he forms a committee of creditors. And the committee of creditors is comprised, as I told you, entirely of the financial creditors of the corporate. Following all the deliberations and the meeting of minds and all the discussions, taking into account the financial situation of the corporate debtor, there is an information memorandum which is required to be drafted by the insolvency resolution professional, which lays down criteria for a potential resolution applicant, so that any potential resolution applicant, which may be outside the scope of the COC, they may submit plans to the insolvency resolution professional for a revival. For example, there may be a third party which may be interested in taking over the assets of the corporate debtor. And upon the approval of the committee of creditors and the adjudicating authority, the successful resolution applicant can take over the corporate debtor. Now, all this process of the corporate insolvency resolution, it has to be completed within a period of 330 days. Initially, when the code was enforced, the period was 190 days, extendable up to again 270 days. What was the practical experience and the difficulties which were being faced was that the timeline was being flouted time and again. So an amendment was made in the court that this entire period of the period of resolution process has to be completed within a time period of 330 days. It is still difficult considering the number of cases which are filed in the NCLT, but then again, it's a welcome move in the IBC. So the process has to be completed within a period of 330 days from the date of admission of the corporate insolvency resolution process application. So if the resolution plan, which is drafted, is approved by the NCLT, then the plan becomes binding of the corporate debtor, and all the employees and members and guarantors, stakeholders are paid according to that plan. If it does not, or if the corporate debtor flouts the plan which is drafted by the Committee of Creditors under the supervision of the insolvency resolution professional, then the corporate debtor goes into liquidation and the assets are distributed as per section 50. So with this in background, I now come to the issues and challenges and the way forward, the implication of the 1-year suspension of the insolvency process under the Insolvency and Bankruptcy Code. Now, as we all know, the COVID pandemic has had a disastrous impact on the economies world over. Because of the impact, because of the fear of the spread of the virus, because of this fear of the spread of the virus, the government introduced a lockdown. This has been done the world over. So what happened because of the lockdown? There was a complete disruption of the economic processes. There was disruption in the supply chain. There was a considerable decrease in the demand of products. We were all shocked to know that the price of the oil became negative. There were malls, cinema halls, shops, all had to be closed. And there was not one sector of the economy which was not adversely affected by the COVID-induced lockdowns. We see the plight of migrant workers every day. We see small businesses, MSMEs, wanting to revive, but afraid that they may not be able to because of the mounting debts, which they may have undertaken and which now may be very difficult for them to repay, especially considering the fact that they are no longer in operation because of the COVID-induced lockdown. So there was a total chaos, and one of the measures as part of the economic revival package, which has been announced by the government, has been the 1-year suspension of the insolvency process under IBC. The government has proposed a section 10A to be included in the IBC, whereby, now what does this section do? This section, it suspends for 1 year section 7, section 9, and section 10 in wake of COVID. Now we just now discussed what is section 7, what is section 9, and what is section 10. Section 7, as I discussed, empowers the operational creditors to file insolvency proceedings. Section 7 empowers the financial creditors. Section 9 empowers the operational creditors. And Section 10 empowers voluntary insolvency. For example, if a company wants to file an insolvency proceeding voluntarily and wants to shut down, even that company is empowered. But with the announcement by the Finance Minister on 17th May 2020, the operation of these specific sections has been suspended. Initially, they were done for a period of 6 months. Now, they've been extended to 6 months more. So for a period of 1 year, the insolvency proceedings against the corporate debtors has been suspended. And what does the government say? The government says that it intends to exclude debt relating to COVID-19 from the definition of default under the code. I just discussed the definition of default, inability to pay the debt. And so what does the government do? The government has said that the definition of debt will not include COVID-related debt or debt relating to COVID-19. And an ordinance will be promulgated in this regard. Now, what is exactly the meaning of debt related to COVID-19 has not been clarified yet, and a clarification is awaited. but it has also been specified that cases which have already been admitted in the NCLTs will remain unaffected, and their corporate insolvency resolution process would go on in a routine manner. The government has also the government also says that this move has specially been enacted for the protection of the MSMEs, to save them for liquidation. They may have mounting debts due to the disruption of their operations, and there may be cases where they may not be able to pay their debts. And of course, in this time, because of the mounting cases against the various corporate debtors, there may be a deluge of cases, COVID-induced cases, COVID-induced lockdown, which caused economic distress, and there may be a deluge of cases which could burden the National Company Law Tribunal, a process which is currently or apparently not in a position to decide such a huge deluge of pandemic-related cases. The government says that the COVID did not allow business as usual. In February, there was an announcement by the government that COVID would be considered as a force majeure, and therefore, this is a very, very unprecedented situation, and entities are bound to face cash flows, and hence they cannot be made to be susceptible to the rigors of the insolvency proceedings, especially for a period of 1 year. Also, one of the reasons for the rationale for suspension of the insolvency proceedings for a period of 1 year was that in these times, the government thought that it was impossible to have a time-bound resolution of the insolvency process. These times when we can't venture out of our houses, only venturing out for essential supplies, etc., it becomes very difficult for the insolvency resolution professional under the code to conduct physical examination of the assets of the corporate debtor for the purpose of its valuation. So that was one more practical difficulty, because of which the operation of these sections was suspended. Another reason why the government suspended these sections was to provide protection to the MSMEs. MSMEs are micro, small, medium enterprises, which have been defined under the MSME Act. The government also has revised the definition of MSMEs under the MSME Act. According to the Ministry of Micro, Small and Medium Enterprises, the government has increased the criteria for micro enterprises from up to 1 crore to 5 crore, for small enterprises, 10 crore, and then the medium enterprises, about 20 crores. This is a significant revision. If you see this diagram, this is a significant revision from the previous figures. Now, why this has been done and aligned with the suspension of the sections triggering the insolvency process, this basically was to provide protection and to the MSMEs, and to enable more and more small entities to come within the ambit of the MSME Act, so that they can get protection under the Act. Moving forward, the move by the government has evoked mixed responses from various sections of the society. Although the intention of the government has been really commendable to protect small entities, small debtors, and also to prevent a liquidity crisis from escalating into a credit crisis if more and more insolvency proceedings are initiated against them immediately. And there have also been criticisms against the move of the government, and the major criticism which has been, I'll highlight it now. The first one being that the suspension of the these sections, you know what it does is, it is really not a solution to the problem, and it is merely putting the problem on a back burner. What does it say? It suspends the insolvency procedure for 1 year. So it basically puts the problem on a back burner. And what happens is that the moment this ban is lifted, what would happen is, again, there is going to be a deluge of cases, and which either you indicate a capacity building exercise of the NCLT, otherwise, again, the NCLT will be burdened with a deluge of cases the moment the ban is lifted. Or unless, you know, there are like monetary policies or there's an infusion of liquidity, the RBI's move to cut down the repo rate is a welcome move, but a lot more needs to be done to handle this problem. Similarly, if we see that there may be, you know, the corporate debtors or some stakeholders who are not consulted before this move, there may be situations where the corporate debtor himself may have had disruptions in his business or may not want to carry on his business. And since there is a provision under the section 10 of the IBC that the corporate debtors can also take voluntary liquidation, but a blanket ban of this sort prevents them from doing so. Now, in this situation, what is happening is, you are telling a corporate entity which is unable to carry on its business, you are telling him that you cannot file an insolvency. You have to carry on like it is, even if you don't have assets, even if you don't have monies to run your business. So in such cases, the corporate debtor who voluntarily wants an insolvency proceeding cannot approach the NCLT to get his debt restructured. Coming to banks, the MSMEs or all the corporate entities have been given the protection for a period of 1 year. But what about banks? Now, in this situation where you are postponing the insolvency proceedings for 1 year, the banks may face a catastrophic situation wherein they may not be able to proceed even against the willful defaulters. And it is also very difficult to determine who is a willful defaulter and who has defaulted due to the COVID pandemic. I hope the ordinance clearly defines what does debt related to COVID pandemic mean, and that debt should be causa of, you know, the default. It should be the real cause of the default. And there should not be a situation where the banks are unable to recover their amounts, you know, against the willful defaulters. Now, one more apprehension is that when the proceedings would actually be resumed, the banks would have to take steep haircuts. And why only banks? All the other creditors may have to take steep haircuts, because there's a saying in the recovery process is that the newer the default is, the newer the debt is, it's easier to recover it. So as and when the time elapses, the value of assets of the debtor diminish, and it is very, very difficult to recover the full amount of debt. So in this case, the banks and the other creditors may have to take a deeper haircut amidst economic slowdown of the value of assets, and you know, the value of assets may be eroded significantly. Now, going forward, so we've highlighted the problems, we've highlighted various issues with respect to the 1 year suspension. So with all is not, let's not be negative all the time. Obviously, there is again a way forward. And what is the way forward to maneuver around this 1 year suspension is that there is a mechanism called the alternate dispute resolution mechanism, which has been really thriving in recent times. I've been a champion of alternate dispute resolution mechanisms. There is nothing which prevents the creditors and the debtors to sit on a table. There is meeting of minds, they negotiate amicably, they restructure the debt pursuant to amicable negotiations themselves. This, I would say, is the best solution in the pandemic-induced era. There is nothing better than sitting on the table, either through mediation or through negotiation, and through mutual consent, mutual agreement, and mutual meeting of minds, try to solve the problem then and there, rather than approaching any fool. Besides that, there was also a June 7, 2009 notification of the Reserve Bank of India, which provided a prudential framework for stressed assets. And in this notification, the RBI advised, in what happened was that the RBI advised the banks to have an ADR mechanism, have a friendly, amicable negotiation process with the corporate debtors before actually initiating the corporate insolvency resolution process against the corporate debtors. This was a pre-COVID move, and this can be an excellent move under this RBI's prudential framework for stressed assets scheme in the present times. I've had conversations with a lot of bank officials which have already started giving advisories to their clients and advising them to renegotiate or pay their debts in a time bound manner, so that there are in future, after 1 year, there are no claims against them. Further, in the year 2018, there was a Sunil Mehta committee, and which gave excellent, again this was during pre-COVID era, but the suggestions which were provided are relevant, and in fact are now more important during the COVID-induced time, especially when the resort to IBC is not there. There were two suggestions there were a lot of suggestions, and amongst them I would like to highlight two suggestions which were given by the Sunil Mehta committee. One was the formation of asset management companies and the resolution by the asset management companies. Now, what these asset management companies do, they amalgamate all the bad debts of the various corporate debtors, rather than each and individual corporate debtor approaching a bank separately to give them some relief. So the asset management companies, there was also a Sashakt India AMC, which was set up by the government, but it was not operationalized. So the idea here is to turn around delinquent firms through mergers and acquisitions, which are facilitated by a fund. There is also a concept of asset trading platform, which was recommended by the Sunil Mehta committee. The asset trading platform is basically nothing, but it creates an exchange for trading distressed assets of the delinquent companies. It is quite prevalent in other economies, and at that time the proposal remained on paper, but this is an excellent time to implement this proposal as well. Now, there can also be one more suggestion, that there can be a government-sponsored fund to provide interim finance to businesses which seek to restructure themselves, which hitherto sought to restructure themselves under the IBC, but since IBC is not in the insolvency process is not implemented for a period of 1 year, then the resort should be, the government should help through this sponsored fund and help the entities to restructure their debts. Going forward, again, reforms in LC&T are needed. Reforms in how a committee of creditors, the proceedings under the committee of creditors is conducted are needed. What was happening was in a lot of committee of creditor meetings, what happened was different stakeholders from banks, different stakeholders from financial institutions, when they were invited for the meeting, a lot of times, see, the intent of the code was, the main advantage which the IBC had over the winding up operations under the Companies Act or the SURFACI Act or the DRT Act was a time-bound resolution process was provided. But in practical, when working of it, what was happening in the committee of creditors was that each and every entity wanted to go back to the table, wanted to go back to their bosses. Either they were not apprised, instructed properly, or they wanted, or their, the higher ups wanted to know the margin of haircut which they would be required to give. What was happening was they were going back to the tables again and again, going back to the higher ups again and again, and it was causing considerable delay in the resolution process. So all these practical aspects need to be streamlined. These practical difficulties need to be streamlined. We need to have more judges in the NCLT to deal with the cases which would come forward. Moving forward, the insolvency proceedings under the IBC have been suspended, but that does not mean that there are no other alternative remedies available. We have Section 230 of the Companies Act, which provides for a scheme of compromise and arrangement between the creditor and the debtor. And here in this kind of scheme of arrangement, all the debtors, whether secured, whether unsecured, they can come. There are times where the company has been liquidated under the IBC, but the creditors and the debtors have invoked Section 230 of the Companies Act. There can also be a solution of the operational creditors filing a reference under Section 15 of the MSME Act. Now, most of the MSMEs are operational creditors. So this MSME Act may be a boon to them. They may, under the Act, the debtor is liable to pay within 45 days from the receipt of goods and services, and Section 18 of the Act mandates that the operational creditor can make a reference to a facilitation council known as the Micro and Small Enterprise Facilitation Council, and then that council would decide the dispute, and within a time period of 90 days they would make a reference. There is also a provision of ADR conciliation in the MSME Act for these kind of disputes between the creditors and the debtors. And there's also a very important mechanism of online filing of case through MSME Samadhan. It's a portal, you may check it out. Moving forward, we always have our good old recovery laws, but obviously they are a last resort. We have a summary suit under Order 37 of the CPC, or you can have a normally recovery suit under the CPC. There can also be a commercial suit as amended by the Commercial Courts Act of 2015. Now, the reason why a lot of people refrain from going to the commercial courts was the difference in the stamp duty, the court fee which is paid under the suit initiated in the Commercial Court Act, or vis-a-vis the application under the Insolvency and Bankruptcy Code, there was a vast difference. And finally, what I may say is that, see, we've provided a 1-year suspension of the insolvency proceedings, a huge respite for all the corporate debtors, no doubt about it. But one must always ensure that there is no willful default or any unscrupulous practices which are happening due to this 1-year suspension. So I strongly, feel that there should be a director, any bank's higher official, or any institutions, credible institutions, higher official, or even judge of the High Court or the Supreme Court, which may be, part of the directors of the corporate debtors, or which may, there may be a forum wherein, the corporate debtors, the potential corporate debtors may, the potential operational creditors may file a list of the corporate debtors against which they have their claims. The insolvency process may not be initiated because of the ban, but definitely we can have a database wherein the operational or the financial creditors may file the names of the list of entities along with credible documents, not just like that, along with the credible documents that, look, I supplied goods on such and such date, they were payable on so and such date, or I provided loan to this person on so and so date. it was payable on such and such date. So the proceedings do arise and they are only suspended right now. So if we can have a database and then we can have some institutional directors to oversee the functions of those potential corporate debtors, and in order to prevent any unscrupulous practices during the period of suspension, then that would be a welcome. So with this, I end my presentation. Thank you.
Thanks a lot, ma'am. It was a really informative lecture. Thanks a lot for sparing out time for us out of your busy schedule. Your lecture was really informative and enlightening.
Thank you
So
so much.
now I request all the participants to fill the Google form which I have just sent on the live chat so that we can issue you certificates. No, messaging would not be admitted. Just you have to fill this Google form. Just messaging your name along with institute name would not work. Google all the students who have filled this Google form will be sent a certificate of participation from our side. No one else. If anyone has any doubts or queries, you may ask in the live chat only. Ma'am, in the live chat, you are receiving messages like "Thank you, ma'am" and etc.
I can't see the chat. Yeah, just a second.
Ma'am, there is a question also.
Can you just read it for me?
Yes, ma'am.
Okay, I can read one question. What does the term white knight means? And are there any chances of this suspension period to get extended? So now in mythological terms, white knight was a person who used to come and help princes in distress or anybody in distress. So now in terms of corporate insolvency resolution process, in a normal circumstance where uh, a corporate insolvency resolution process is going on, and there is a committee of creditors which is discussing. So what happens is that the insolvency resolution professional may also provide opportunities to third parties and those third parties may be going beyond the committee of creditors. Those third parties may be very well off financially, and in normal times they may be able to take over the assets of the debtor and help in the revival process. So those third parties which help to revive the debtor are known as white knights. I hope I answered your question.
Yes, ma'am. Thanks a lot, ma'am. Ma'am, there is one more question.
uh, yeah, are the employees of corporate debtor considered to be operational creditors? Yes, the code specifies it. Yes.
Thanks a lot, ma'am. And there's one more question, and this would be the last question for the session. It says, what about securitization act by banks?
I didn't understand. What about securitization act by the banks? It's a separate law in itself.
Okay.
But
So,
definitely the insolvency code was supposed to be more effective than all these laws relating to securitization or the debt recovery tribunal, recovery of debts by DRT.
okay. Thanks a lot, ma'am. It was really informative
I'll
lecture.
just end with the last question.
Yes, ma'am. Sure, ma'am.
It says 180 days is limit. First of all, 180 days is no longer in vogue. There has been an amendment and it's 330 days. And it is the limit for completion of liquidation. No, it is the limit for completion of the insolvency resolution process. And insolvency resolution process commences from the date when NCLT admits the petition.
Okay, ma'am. Thanks a lot, ma'am, for giving us such a wonderful lecture.
Thank you for the
I guess by
opportunity,
now,
Ishan.
thanks a lot, ma'am. I guess by now everyone must have filled the Google form. If not,
Can I log out, Ishan?
request everyone. Yes, ma'am. You may log out now.
Okay, thank you.
I request everyone to fill this Google form. Also, would like to thank my team, Mudit Saxena, Rudrabhishek Chauhan, Devesh Tiwari, Anshul Dhingra, Yash Sharma. Without their support, this webinar would not have been possible. Thanks a lot, guys, for joining us. I would be ending this meeting